Welcome everyone to the beginning of the first session of Group 1. So I'm Michael Lowe, I'm going to moderate this group. And just by way of introduction, let me say that we've got 4 papers today. Each paper has been allocated 25 minutes, so roughly 15 to 20 minutes of presentation, and then the rest of the 25 minutes, 5 minutes or so for Q&A. If you have any questions for the speakers, could you send those questions to me in the chat function? You can see the chat function at the bottom of the screen, and then I'll read the question out to the speaker. The speakers will get a 3-minute warning if they're coming to the end of the session, and then at the end of 25 minutes, we'll have to stop to keep to time. So I think now we're ready for the first presentation by Professor Queenie Lai, who's going from CUHK Law, who's going to speak about changing trends of legal education in Hong Kong, turning law students into lawyers and future leaders of society.
Thank you, Michael, for the introduction, and thank you again to you, Steve, and Dean Wu for organizing this successful biannual conference to provide a space for us all, legal educators, students, alumni, practitioners around the world, to engage in dialogues and to explore ideas and approaches in legal education. So let me just share my slides. It is my great pleasure to kick off the first parallel session with changing trends of legal education in Hong Kong, preparing law students to be lawyers and future leaders of society. There are 2 parts to my presentation today. First, I will share with you my observations of changing trends in Hong Kong legal market and what it means to Hong Kong legal education. What are the changing trends of legal education in recent years? How do we adequately prepare students for the future of work? Are our students ready for the workforce? Then I will try to answer questions that we as legal educators should carefully think about. And these are really common themes that apply to all law schools, not just law schools in Hong Kong. What is the purpose of legal education? Post-pandemic, can our legal education system cope with a more complex, uncertain future? Will our education system produce leaders able to cope with tomorrow's complexities? And as educators, how do we make a lasting impact? First, I'll talk about talent trends in Hong Kong legal market. The following are my observations in changing talent trends in Hong Kong legal industry over the past decade. As a common law jurisdiction, Hong Kong law system is built upon the English law system, and it used to be the case that good native fluency in English is the prerequisite to joining law school or working as a lawyer in Hong Kong. Mandarin Chinese capability to be a lawyer used to be a bonus, but not essential. I remember 2 decades ago, I was interviewed in English for my training contract at an international law firm. The partner was surprised my Mandarin was native fluency level. Now, these days, Mandarin and proficiency in Chinese language is a must or basic minimum prerequisite to be a lawyer in Hong Kong. Trilingualism, Mandarin, Cantonese, and English seems to be the norm now. There is high demand for professionals who are business proficient in Mandarin to proofread, translate, and draft in both languages. So from a corporate law perspective, being a corporate lawyer before, Hong Kong has one of the world's leading stock exchanges and home to many financial institutions, and it's really the gateway and connector to China. The majority of initial public offerings in Hong Kong Stock Exchange in the past decade are all Chinese issuers, including many major homecoming listings with big names such as Baidu, Alibaba, JD.com, Kuaishou, SenseTime. Admittedly, listing on the Hong Kong Stock Exchange has plunged significantly during the last year due to global market volatility, China's economic slowdown, and COVID-related reasons. But given Hong Kong's strategic importance, the city's prospect will bounce back once the pandemic-related volatility subsides, and Hong Kong will continue to act as a very important venue that bridges China and the rest of the world. With this in mind, law firms need trainee solicitors in their Hong Kong office to play an integral role in managing clients with established and emerging Chinese companies, Chinese government, and state-owned entities and global financial institutions. Professionals who are culturally sensitive and savvy and have experience managing both mainland Chinese and international clients. In this aspect, CUHK Law noted the importance of bilingual competency in our graduates at both undergraduate and postgraduate levels. So various compulsory and elective courses in Chinese are there to ensure our graduates are workforce ready. At the undergraduate level, we partner with the Department of Chinese to offer electives such as practical legal Chinese and a summer study abroad program in Tsinghua University in Beijing. We have also strategically got two strategic streams to choose from, the Chinese law stream and the global law stream. At PCLL level, we have increasingly popular electives such as writing and drafting commercial documents in Chinese, writing and drafting litigation documents in Chinese, and China practice, which focus on foreign investment rules in China, all ever growing in popularity and demand. The increasing demand for bilingual legal professionals with native Mandarin capability is also reflected in the changing diversity and demography of our PCLL student population. PCLL, for those of you who are not aware, is the Postgraduate Certificate in Laws program, which is equivalent to the former legal practice course in UK, the one-year professional skill-focused training, closely reflecting the work lawyers undertake in Hong Kong. Our PCLL cohort is very diverse and comprised of LLB graduates, JD graduates, JD who have completed their law as second degree, and a significant number of students with overseas degrees from UK, Australia, and New Zealand. What I've observed over the past decade is the changing demography and increased mainland Chinese population, non-local Hong Kong students, joining our PCL program to become lawyers in Hong Kong. This change, I think, reflects the hiring needs of law firms and show that there is a continuing demand for bilingual native Mandarin speakers, and this is reflected in our PCLL student population. Another trend I want to talk about, which often my PCL students come to ask me for advice, is about multiple qualifications, dual or even multiple qualifications. It is almost a norm now for Hong Kong lawyers to consider multiple qualifications. Asia has a large transient workforce, and in a globalized society, students and lawyers equipped with transferable skills want to have the option to work in multiple jurisdictions. So for the UK SQE, as we all know, now to qualify and work in the UK, you need to take the SQE solicitor qualifying exams, with the first exams that took place in November 2021. You need to pass SQE 1 and SQE 2 and complete 2 years qualifying work experience. What I want to share with Hong Kong students and lawyers, 2 points worthy of note, is that SQE now allows overseas students to sit the same exam as domestic UK candidates without having to sit additional local conversion exams. Hong Kong is also one of the 5 jurisdictions in the world that have successfully applied for exemptions from SQE 2 exams. So from 2022 onwards, SRA has agreed to grant an exemption from SQE Stage 2 and 2 years of work experience to Hong Kong solicitors who have qualified through the training solicitors route in Hong Kong. This means, in other words, it may be easier to qualify as UK solicitor via the Hong Kong pathway. In other words, Hong Kong students who took the PCLL route and qualify in Hong Kong can have an easier pathway to also have dual qualification in the UK by using their Hong Kong training contract experience to seek exemptions for the 16 SQE 2 assessments and the 2 years qualifying work experience as well. I've already known quite a few of my former students who have done the SQE and become dual qualified. I foresee that going forward, dual and multiple qualifications will be the norm rather than for the elite few. I'll briefly also talk about New York Bar. Many students also ask about taking as well the New York Bar. Any law school graduates who have completed a program based on English law system with a duration equivalent to JD program in US, normally a 3-year full-time program, will be eligible to take the New York Bar. In other words, most Hong Kong LLB students will be eligible to take the New York Bar exam to qualify as lawyers, US lawyer as well. Finally, another new initiative worth noting and is of course a new pilot scheme that allows Hong Kong permanent residents who are Chinese citizens with 5 years or more post-qualification practice to pass the special qualifying exams to practice in the Greater Bay Area. This first exam took place in July 2021. Now, once qualified, the GBA lawyers can be employed in Hong Kong and mainland law firms in the 9 mainland cities in Greater Bay Area. This is in line with the Guangdong, Hong Kong, Macau, Greater Bay Area development plans. Our CUHK Law GBA Legal Forum has already received plenty of attention and has discussed in details the potential and ambitions in transforming the 9 mainland cities and the 2 special administrative zones, Hong Kong and Macau, into a new Silicon Valley hub, technology and innovation hub. There is plenty of potential and plenty of opportunities for bilingual Hong Kong lawyers to contribute to this fast expanding market. Next, the third changing trend, which I think not just apply to Hong Kong, but really around the world, is of course the much talk about law and technology. The way in which law is taught and how law work in the future is changing rapidly. And there are 2 aspects to this. First, of course, is the technology in the law industry. Legal sector, compared to other industries, have still not been significantly disrupted by the advent of new technologies. But this situation, I anticipate, may change dramatically in the upcoming years, and law firms and in-house have to prepare for this rapid change to stay competitive. How technology is revolutionizing traditional legal work such as due diligence, discovery, drafting of contracts. Now AI-powered contract analysis softwares identify key concepts in documents, and data extraction means automated data extraction means saving hundreds of man hours in delivering greater value and efficiency to clients. What does it mean to legal education? Given the likely disruption of legal profession, our students and future lawyers need to have careful understanding and awareness of the latest legal tech solutions. At CUHK Law, we have introduced law and technology as elective subjects at both undergraduate and postgraduate level. And at the university level, digital literacy courses, which includes learning of programming, is also made a compulsory course for all CUHK undergraduates. The second aspect is that there's an increase in demand for lawyers specializing in emerging diverse industries and hot areas. Many of my ex-students now are in newly formed departments in large global law firms, departments which we've never heard of before until the recent 2 years. Departments such as TMT and data, technology and transactions, and data privacy. I've also known many alumni and graduates have recently moved into fintech startups to join as in-house counsel or work on the business side as strategic consultants. Many often moving in-house much earlier at 2 to 3 PQEs. Another former student of mine have completely switched career paths and joined a legal tech solution contract provider and worked as their director of Asia Pacific. So these changing market trends means that lawyers really need to keep up to date with the change in regulations and laws to maintain and increase marketability and competitiveness. Aspiring lawyers will have an edge if they are digital natives and tech savvy, keen to learn and adopt the use of AI, legal technology, and apply the same to make their job more efficient in the future. Given the likely disruption to the legal profession with all these technological advances, it cannot be emphasized enough that how important it is for lawyers to continuously learn and network throughout their careers. Now, all the trends of legal market, what does it mean? We know the following. Number one, there is an ever-increasing competition for internship placements and training contracts from JD, LLB graduates and students returning with overseas degree. The need for bilingual competency and native Mandarin speaking lawyers means that we will see local and non-local students from around the world competing for law jobs in Hong Kong. Clearly, law firms see more value and potential in hiring those with bilingual or multilingual competency. The second trend I've observed is, of course, a growing demand for practice-ready or workforce-ready graduates and trainees. Practice-ready means beyond looking for knowledge and academic competency, a good GPA is really a basic requirement. Law firms are looking for professional and personal attributes, critical thinking skills, fundamental lawyering skills, commercial awareness, interpersonal skills, and leadership skills. Society places great trust in our lawyers, and lawyers are represented at all levels in leadership as judges, legislators, general counsels, managing partners, heads of government, heads of corporate, and heads of regulatory bodies. Lawyers lead teams, meetings, and committees and charities. And many of my PCLL students, whom I taught a decade ago, are now senior and seasoned legal practitioners, serving as leaders of society. At the end of the day, we as legal educators are training students not just be practice-ready lawyers, but training our next generation to be future owners and leaders of society. Yet, unlike business schools with extensive literature and focus on leadership training, rarely do lawyers have received training for leadership responsibilities. So how do we prepare students to be practice-ready lawyers and future owners and leaders of society? Very often, the focus in law school on grades and exams and test score underpins what motivates students. Exam-oriented strategies and getting a good GPA is what motivates them. It undervalues interpersonal capabilities, ethical commitments that are necessary for successful leadership. So to conclude my presentation, I have 3 key ideas to share with you all how to prepare students to be practice-ready lawyers and future leaders of society. Number 1, practice-based simulation exercise, learn by doing. Regulators around the world, as we all know, are turning to summative and centralized assessments. For example, the SQE is replacing the legal practice course in the UK. There's the New York Bar exam, there's the GBA Greater Bay Area exam. But experience and research have shown how practice-based simulation role-playing exercise, learn by doing, combined with formative assessment and guided reflection, equips students with transferable skills and ultimately translates to better prepared lawyers. We are not training exam takers. Centralized assessment and test scores only train students who are strategic at taking exams. Soon after exams, the students will forget what they've learned, and law constantly evolves. The focus on centralized assessment and test scores undervalues interpersonal capabilities, practical lawyering skills, emotional intelligence, and ethical commitments that are crucial for success in the legal profession. What we need instead is practice-based simulation role-playing exercise to ensure our students are better prepared lawyers, which is what we are doing at PCLL level. From an education viewpoint or perspective, not only should we keep PCLL and not let it be replaced by centralized exams, we should consider whether every law course at undergraduate level and postgraduate level should include both substantive law and fundamental lawyering skills training. Practice-based role-playing simulation exercise means active learning where students' participation and identify themselves as professionals. I'll give you some examples. For example, business transaction simulations, negotiations, contract drafting, client presentations, client pitch, client interviews, conference skills training, trial advocacy skills, and legal research skills. What our students and aspiring future lawyers of future society need is safe spaces in the classroom setting to take risk, make mistakes, and build confidence. Students need real-world practice and real-world skill and experience, and to be comfortable in practice settings and not be easily flustered when things go differently than planned. The objective should be to ensure that there is plenty of opportunities for them to develop transferable leadership and lawyering skills. Formative assessment means that there is frequent and constructive feedback, opportunity for guided reflection and self-correct by applying the feedback to future exercises and improving on weaknesses. The opportunity to practice these skills in classroom setting is invaluable, where performance can be reviewed in an impartial and constructive way, and it will make attempting the same in the harsher light of practice much less daunting. The second I advocate is beyond the classroom setting, is that students should practice leadership skills through service and leadership opportunities, such as getting involved in mooting competitions, student law gazette, student law societies, legal venture clinics, pro bono work, mentorship programs, overseas exchange, college, university, and professional and community activities. We have to create more of these opportunities for students to nurture growth and confidence beyond the classroom. Last but not least, I also advocate value-based education for law schools. The future is an uncertain destination and changing space for our law students. Beyond legal knowledge and academic competency, our responsibility as educators is to equip our students with tools, values, skills, and mindset that they need to navigate the faster flow and the ever-changing tides, which we know they will encounter when they leave us. More important than knowledge, I think, as educators, is to teach them the right values and mindset through words and action, the proper use of knowledge, the ability to discern what is right, true, and lasting. The future of work is about the right values: fairness, equality, inclusion, sustainability, innovation, work ethics, justice, humility, empathy, and a growth mindset. At CUHK Law, we have at the PCLL level, professional conduct course for lawyers. At JD level, we have ethics and jurisprudence course. And to promote awareness on professional ethics, we have 2 new initiatives this year. We have introduced a professional ethics student essay competition where all our students from LLB, LLM, JD, and PCL programs can participate through legal research and writing. And it is aimed at promoting the awareness of professional ethics among CUHK Law students through research. The second initiative we've launched this year is a legal ethics and professionalism sessions certificate workshop for our LLB, JD, and LLM students, taught by our careers director, Paul Mitchett, QC. But beyond these courses, I think a value-based education means that ethics and professionalism should be taught pervasively at every stage of legal education, even at undergraduate level. At every law course, every interaction with law teachers who act as role models, we have to inspire our students to have the right values and mindset through words and action, the commitment to professional integrity and ethics, to seek and to serve, and be committed to continuous self-improvement. And to conclude, this is what I think the purpose of legal education. And to answer my very first question at the start of the presentation, how we as educators can make a lasting impact. The task of educating tomorrow's lawyers in professional ethics cannot be left to one or more teachers who are specialists in the system, but it should be rest with every law teachers involved and every professional mentors involved. Thank you for the opportunity to share my views at this conference, and thank you for all to joining me at this session. Thank you.
Thank you, Queenie. We've had 3 questions, but we've only got a couple of minutes. The first question is from Shmuel Yerushalmi, and he wants to know whether you think that COVID-19 pandemic has created opportunities for new approaches to legal education.
Thank you for that question. Yes, definitely. I have in another session, talk in detail about the benefits, pros and cons of online learning. There are pros and cons. The cons is, of course, there is less in face-to-face social interaction for connections. And I've repeatedly emphasized that training for practice-ready lawyers, it's not just legal knowledge, but also interpersonal skills and emotional intelligence. So in that aspect, I think face-to-face learning has still got its benefits and merits. But I agree, online learning, pandemic, it gave us a real opportunity to look at Zoom and online learning. And I've advocated in another seminar about the need to have active learning exercise tailor-made for Zoom learning, where students can still be involved in learning, such as client presentations, contract drafting through an online setting. So, and the benefits is, of course, flexibility and higher student participation. And this perhaps goes beyond the topic today. We only have a few minutes, but I certainly think it's actually an opportunity for us to learn from this crisis. We can in the future we have to think about how online and face-to-face learning would and blended learning would give our students the best educational experience. Thank you.
Thank you, Queenie. There are 2 more questions, but we haven't got time for them. So Esther Erlings has got a question about dual degrees. Brian Tang from HKU about wants your views on clinical and experiential learning. But I'm afraid it's going to have to suggest that perhaps they could email you directly because we've run out of time, or message you directly. But we're going to have to move on. Thank you, Queenie. So our next speakers are Professor Lisa Toohey, Monique Moore, and Sara Rayment from Newcastle Law School, not in the UK, as it says in the program, but from Australia. So could I pass over now to Professor Toohey? As before, please put any questions in the chat for me.
Thank you so much. And I'm sorry that this far into the pandemic, I'm asking the question of whether everyone can see my slides okay, but I hope that those are visible for you. Thank you. I'm Professor Lisa Toohey from the University of Newcastle Law School in Australia. And it's a pleasure to be back virtually at the Chinese University of Hong Kong, especially as during pre-COVID times, I really enjoyed visiting your law school in definitely one of the world's most vibrant and innovative cities. So today, on behalf of my colleagues, members of my research team, I'd like to present the results of what is really a multi-year research, industry engagement and teaching project that looks at the question of how to facilitate innovation in the legal profession. And I should add that our presentation today is based on a chapter that's forthcoming in an edited volume from the UK. It will be published by Routledge in the coming month. And you'll see on a couple of the slides, I put a QR code that will link you to that publication if it's of interest to you. So in 2018, we ran what we confidently believe is the first Australian law school course that was dedicated to legal design thinking. And what made this course interesting is that we created the course out of a wish to focus on the impact of technology on the changing practice of law. But our research actually led us to change the emphasis of the course fairly quickly, and we decided instead to focus on using collaborative human-focused approaches and to lessen our focus on technology, and to focus instead of on technological skills, to focus on mostly analog experiential learning. So for example, rather than directing our students to build apps or really explore in depth the applications of artificial intelligence, we focused on principles of legal information and visual law and encouraged the building of literal physical old school prototypes to represent potential solutions to scenarios that we set up. And as we refined our approach over a couple of iterations of the course, we came to refer to it as technology informed, but not technology focused. And so what I'd like to do in the next few minutes is to introduce in a little more detail the rationale for the course design, including the data from our research project on which our course was based, then talk a little bit about the features of the course itself, and then give some closing reflections as well. So futurists such as Siskind obviously emphasise the importance of lawyers being innovative in order to respond to potential disruption, particularly from technology. However, while there is a lot of exhortation that lawyers should innovate, there's very little information provided to lawyers on how exactly they should innovate. And we all know and accept, I think, that the legal system is at a crossroads, and as legal educators, we're quite preoccupied with the importance of helping our students meet this new world of legal practice. But the question that no one has really answered so far is how exactly do you get lawyers to be more innovative? And so that was very much the focus of our research project. And in our published work, we've explained some of the particularities of the Australian legal education environment, particularly that many of our graduates don't actually aspire to be lawyers. So some of them will go into legal practice, but many of them won't. However, notwithstanding this feature of the Australian legal education market, law schools tend to pay great attention to the voices of the profession. And over the past years, there have been several very influential reports published by various state law societies, both highlighting the skills, both highlighting the importance of teaching lawyers to be innovative. Mostly, however, the recommendations focused around teaching technology and encouraging lawyers to have skills such as coding. And we wanted to explore and test this assumption in a little bit more detail and to really question whether the teaching coding approach was the correct one. So the project that we have been involved in has three main research questions. And the first is, how exactly are lawyers and the legal education sector responding to this innovation imperative? Secondly, what are the kinds of structures and educational experiences that will really help young lawyers and older lawyers for that matter to actually be innovative? And how exactly do we as educators teach these skills effectively to both lawyers and to future lawyers? So we undertook a qualitative study to build our understanding of innovation in law, talking to educators, to law students, and also to those actively practicing in the area. And we also built and tested our pedagogical approach through a series of courses over a couple of years. So our key insights from the data, so the interviews that we undertook and the data that we collected, is that firstly, innovation is often misunderstood. In our experiences, lawyers often tend to assume that innovation needs to be big, that it needs to be disruptive, but really what we have heard over and over is that some of the most successful innovation is incremental and often not game-changing, but has real benefits delivered for the lawyers and for their clients. The second sometimes overlapping misunderstanding that lawyers and law students often have is that innovation equals technology, and that in order to be innovative, you need to produce something like an app or some sort of artificial intelligence. And time again, our interviewees highlighted their frustration with their colleagues and peers who seem to think that an app would be the solution to everything. Our second key finding was that there is definitely a need for cultural change and for education of both lawyers and law students. So law firms are really struggling to work out how to develop a culture of innovation. They know that experimentation is essential, and I'll come back to that point about why that cultural change is so difficult. But at a personal level, innovation is something that most lawyers find quite hard. And our key finding here was that in order to successfully educate lawyers to be innovative, the best thing that we can do is to teach lawyers a method of how to go about innovation. And here we focused on the use of a design thinking methodology. And our third insight from our stakeholders and from other educators, as well as from law students, is that university legal education really needs to do more to help students understand the world that they're going to be graduating into, and to give them confidence in their ability to innovate and to help develop their skills to understand what it is that their end users actually need they need them to do. Okay, so why is change so hard in the legal profession? Well, time and time again, the literature base and our respondents identified that the classic lawyer personality tends to be fairly change resistant, also very independent. So lawyers don't tend to like working in teams. lawyers tend to be quite prone to perfectionism, and I laugh even saying that because I can understand that, and that lawyers are very oriented towards speaking and writing. And that is quite a contrast to what we know, again, from literature and experience that is required for innovation. So innovation requires essentially a very optimistic outlook and a high degree of resilience, and especially being comfortable with the fact that you might fail in your innovation, and that's something that lawyers find very challenging. And also being comfortable with the fact that the process is a little bit ambiguous. When you set out to innovate, you don't know where that process is going to lead. And that's something that tends to make lawyers quite uncomfortable. Also, our typically very independent lawyers tend not to enjoy working in interdisciplinary teams. They are generally much more comfortable doing things themselves and sort of being a jack of all trades. And that's not what the evidence says is required for successful innovation. And then last but not least, even though lawyers tend to be oriented towards writing and speaking, that's quite different from what their clients will often demand. So clients are increasingly demanding very visual and practical approaches, and that tends to be a little bit at odds with preferred lawyer communication methods. So I should also say the research specifically on lawyer personality is very, very interesting and something that we'd like to do more work on, but it is a little bit limited at this time, and it is a little bit outdated, but it does, the published literature does gel quite well with what people anecdotally know to be true about lawyers. Okay, so the big question that most people have when we talk about our project is why we decided to use a design thinking method, and why not teach legal tech or app design or a coding approach. And so before I talk about the course itself, I just want to explain our rationale a little bit. So first and foremost, we were really keen to avoid a very lawyer-focused narrative that talks about how technology is going to help or harm lawyers. The reason for that was we see that as really being at odds with the values that we and many members of the legal profession have in taking a client-focused approach. So in other words, when you're thinking about what technology can do, you're generally thinking about what it can do for your law firm profitability or to make your life easier. Whereas if you focus on what your client needs and focus on, you know, the human side of things, you may not always choose a technological approach. Secondly, a fairly practical concern is that the pace of technological change has certainly been fast, but it's not as fast as has really been predicted. So while there's no doubt that disruptive technologies will eventually transform the role of the lawyer and that certain tasks have been automated, there are many things about legal practice that remain the same and remain very human focused. And certainly the consultants believe that in the foreseeable future, much of the higher value work that lawyers will do will still require that complex reasoning and that very skillful understanding of human nature, and that can't be replaced by machines anytime soon. And I think finally, and most importantly, we really didn't want to centre technology in the innovation process because of the risk that students especially begin to equate innovation with only technology. And this is something that I've mentioned before. It came up frequently in our interviews, and particularly lawyers in practice who are very innovative and lawyers who are in legal innovation and tech roles emphasised in our interviews just how harmful they felt it was to take a technology first approach. Okay, so having explained the rationale for why we designed a course based on legal design, what actually did we do? So the second part of this presentation, I would like to briefly introduce some of the features of the course and explain some of what worked well and perhaps what worked a little bit less well. So the first feature of the course was that we tried to design it around problems brought to us by the profession. So we had not exclusively a social justice bent, but that was very much the types of challenges that our law firm partners brought to us. So up here on this slide, you can see some of the scenarios that we gave our students in class to find an innovative solution for. Now, we found that the choice of scenario was very, very important. Initially, we didn't narrow down the scenarios. We just went with what the law firms provided us. But we did find that it was important for students that they not have to deal with really unfamiliar areas of law. So where the scenarios were too legally complex, or they did have those more complicated areas of law, students would lose their focus on the design thinking process and would become preoccupied with trying to understand the legal doctrine and the legislation that apply to the scenario. So over time, we tended to work with progressively more simple scenarios, but all of them are what are called wicked problems. So where you start to explore the problem and you aim to solve it, it generally throws up a whole lot more problems, all of which are very hard to solve. And we randomly allocated these challenges to the students who were enrolled in our class. I think the second thing that we learned through the various iterations of the course is that it was very, very necessary to take the students through the legal design process in a really structured way. Initially, we let them have free rein, and we discovered that students didn't enjoy sticking to the legal design process. It may not surprise you to know they want to jump straight to the solution. And so in subsequent iterations of the course, we stepped out the legal design process into the different components, and we made sure that they did structured tasks on each area, of the legal design process, so that they couldn't skip through any of the stages. And we found that that had really good outcomes, and that the innovations that the students came up with at the end were much better when they had that more structured approach. The third thing that we did was we really highlighted skills integration, focusing on what we'd learned from our research about being the really key skills for innovation. And things that we highlighted here were creativity skills. So that idea of throwing out lots of ideas without judging and analysing the efficacy of those ideas. So separating out the idea generation from idea evaluation. We really highlighted a playful but serious approach. And so you'll see on this slide that we use things such as plasticine, Lego, we use a lot of paper, and we use a lot of physical sorts of artifacts to really encourage our students to become familiar with visually representing the innovations that they were considering. And the reason for that is to highlight the importance of what we call prototyping. Now, we mentioned right at the beginning of this talk that students are not comfortable with failure. And so prototyping is a really important step in the process to try and avoid big failure. So avoid creating an innovation that's useless to the end user by getting feedback early on prototypes. And so this is something that we really highlighted to our students as being absolutely essential. And so in terms of what we actually did in the course, we allocated a really large amount of time to doing these practical structured tasks, helping students work towards their own group challenge, so their big scenario, but also setting them some mini challenges to try and help them develop the skills that they needed for each stage of the methodology. So for example, we asked them to create little mini redesigns of some consumer contracts, and that was to help build their confidence in visual design skills before moving on to a larger size project. We also found over time that it was important to delay our discussion of technology and the use of things like AI and apps until towards the end of the course. So in other words, we really highlighted the importance of going through a legal design methodology. And once they had really understood what their users needed, then considering whether technology might be an important part of their end innovation idea. So this avoided students being predisposed towards having a technological solution and instead made sure that they were really squarely focused on user needs. Sorry, I'm just checking how I'm going for time. Okay. And then another thing that we did to make sure that students stepped through the process was we built that the drafting process into the assessment. So the assessment in the course included a portfolio where the students had to show their working. So they need to show their drafting process. And this was really important to make sure that students didn't jump through any of the process steps. So they had to submit their refined version of a prototype. So they didn't need to create a working innovation. They just need to have a refined prototype, but they did have to show us how they got user feedback, the changes that they'd made, the research that they've done, and so on. The remainder of the course assessment included a class participation mark and also a research essay based on topics related to the student, the coursework. So you had a combination there of really very typical assessment, but also this much more unusual assessment portfolio. Okay, so it's the way that I think I've presented it is that it was, you know, a fairly simple process, but of course the reality was that it wasn't without its challenges. In the early days, it was quite hard for us to communicate the course's value proposition to students because it was quite unusual and because it was the first of its kind in Australia. That's become less of a problem as time has gone on. In the early days, there were not adequate resources, so we had to create all of our course resources ourselves, and that included having a lot of guest lectures from industry. And then the final challenge, especially in recent times, has been economics of running the course. So this is something, because it requires a lot of conversations with students and it's very interactive, it's something that is hard to teach in a very large group environment. So ideally, we need a class size of under 40 students, and depending on the university, that can be a little bit challenging. Okay, so just briefly, because I know that everyone always wants to see what our students have produced, here's a couple of our favourite examples. So one group of students produced some dynamic terms and conditions for a bank, and even though they look fairly straightforward on the outside, they're not only written in plain English, but they also have interactive pop-up information, including informational videos that will explain the terms and conditions to the end user in more detail. And the second example that I have is a chatbot that our team created, one of our teams created, to help people find information about the separation process. So where they were separating from their partner, what sort of information they might need. Okay, sorry, I'll skip over the video in the interests of time. But in terms of concluding observations, this has been a really amazing project to be involved in. It's been really a very rewarding way to connect with students in a slightly unusual subject matter. And our graduates from this course have gone on to do some truly amazing things. It's been very well received by industry. And our graduates have often found roles, for example, managing innovation in a medium-sized local law firm. Our process is ongoing in terms of collecting data to really respond to a demand from industry to have a strong evidence base for how we help lawyers to be innovative. And so this project has spun out not just into research, but also into education and consulting. And so finally, if this sparks an interest for you and you would like to know more, or you'd like to hear more about the research that we're doing, or the way in which we're teaching innovation, then please feel free to reach out to me. And the book chapter that I've mentioned, you can access through that little QR code on the screen. So thank you very much for your attention this afternoon, and I'm very happy to take any questions.
Well, thanks very much, Professor Toohey. And there are questions. So, and not only are there questions, but actually one of our next speaker hasn't turned up. So it means that we've actually got, there's no kind of time pressure. So let me ask the first of these questions. So this is from Brian Tang at the Light Lab at Hong Kong U. And he says this. Let me see if I can just get to the question. Yes, love the approach. At Light Lab at HKU, we use legal design thinking too, but also integrate no/code tech platforms. Especially with COVID, we used e.g. online tools like Miro for brainstorming and Slack for collaboration, etc. Did Professor Toohey use any such online tools?
Thanks so much, Brian. What I probably should say is that the bulk of the teaching that we did in this course was actually before COVID. And so it was really, you know, in hindsight, an incredible privilege to have everybody actually in the room for the course. We did, sorry, when I say that we use a low-tech process, I just mean that we don't get our students to produce automatically a technological solution as their innovation outcome. So absolutely, we did encourage our students to use things like Slack to communicate with one another. Some of them use Teams instead. And we did introduce them to sort of low code prototyping. But we really encouraged them to have the mindset that if they wanted to bring these prototypes to market, that what they would be doing would be engaging with professionals who actually do code. And so they were just building wireframes to illustrate for the purposes of a pitch what their technology might do, rather than actually making the technology do the thing, if that makes sense. But thank you. It's a really good question.
Thank you. Now, Esther Erlings, question for Professor Toohey. What was the background of the teaching team? At my university, Flinders, also Australia, the students take compulsory innovation topics. Of the 3 topics, 2 are taught by a lawyer with a commercial background, and 1 by a staff member from a business/innovation institute. Do you think these topics are best taught by legal academics? And if so, what should be their background?
Look, I think that's always a very, very interesting question, and it's not unique just to, you know, a course such as innovation. There's always that tension, I think, between having people who are from industry and people who actually have the pedagogical expertise to teach a subject matter in a structured and scaffolded kind of way. And so in this course, we basically hedged our bets. So all 3 of us have commercial legal backgrounds. And my colleague, Sara Rayment, was an academic for a fairly brief period of time and actually started her own law firm that specialises in legal design. So she had that very recent industry experience that she brought to it. And my third colleague, Monique, has recently completed a PhD in research commercialisation. But again, she comes from a legal background, but also a startup background. So we were very fortunate to have a team that sort of straddled both industry experience and also the pedagogical experience. But we did also very heavily rely on having guest lecturers so people from industry to come in and talk for a very short period of time about particular issues that they experience in practice. So that's how we dealt with some of the really sort of cutting edge stuff that we were personally less experienced with.
Thank you. And now another question from Josica Coutin at Melbourne. How much time and focus did the students think about and use information about the end user, and how the end user may approach and think about their legal problems? And then really interesting work. Thank you.
Oh, thank you. Look, there was a big difference between the first and second iterations of the course. In the first iteration of the course, we thought that it would be enough to explain to students that they needed to think about the end user and ask them to go and do some survey work. And we didn't watch them like hawks throughout that process. What we found is that they would talk to anybody rather than actually talking to the end user. So they went upstairs and they talked to the staff at reception in the law school. They would talk to people they already knew. They didn't want to talk to strangers or to really work hard to try and talk to end users. So in the subsequent iterations of our course, we tried to deal with that problem because, of course, when you don't talk to actual end users, your innovation doesn't usually respond as well to their needs. So we revised our scenarios and we made sure that end users would be really easily accessible. So that might include, you know, their friends and so on would be potential end users. And then we also made sure that they brought us evidence of the end user consultation that they'd done. So that had to be included specifically in their assessment portfolios. And we also asked them to present their end user research in class, both at the initial stage and at the prototyping stage. So we spent a long time insisting that they really had to talk to humans, and that wasn't always easy.
Could I ask a question, Lisa? I've got a couple really. One question is, I don't know if I missed it, but so you're talking about the sort of skills that you had to equip students with. And I don't know if you mentioned it, but I wondered whether you'd focus at all on collaboration skills.
Yeah, so the feedback that we got from industry early on is that lawyers don't love working in multidisciplinary teams. And also that they often, law students especially, I think a lot of us don't love collaboration. And so, yes, we talked a lot about the process of collaboration. So the students were working on their innovations in teams and their portfolios were marked as group work. So we did sort of make that a prerequisite, and some of our guest speakers that we brought in included non-lawyers to talk about the process of, for example, how does a graphic designer work with a lawyer? How does a coder work with a lawyer? So not how do you become a graphic designer yourself or pick up great graphic design skills, but what are the key things that you need in order to work effectively with someone else on your multidisciplinary team.
That strikes me as a very sophisticated kind of bit of professionalism, really, knowing how to work with multidisciplinary teams and, you know, and knowing where the interface lies between one member of the team and the next.
Absolutely. And I think there's it is a difficult skill to master.
The other thing that struck me, one of the other things that struck me in your presentation was when you said that that you didn't emphasize tech, but more emphasized really practical solutions. And then you said that you thought that most legal work it'll be a long time before most legal work is being done by machines. Now, this struck me as interesting because a couple of years ago, and I agree with it, I'm sure you must be right, it's common sense. But a couple of years ago, we had Richard Susskind. Yes. Of course, if you read Richard Suskind's work and that of his sons, then we're all going to be unemployed pretty quickly. So, I mean, I don't know if you have any, what was your thinking about that?
Oh, we actually did think a lot about these, what we call the Susskind prophecies of sort of doom and gloom. And in Australia, a lot of that is echoed in the work that law societies have done. And I think what tends to happen, which I think is a shame, is that there's a lot about how legal tech will really change the profession and it will decrease profit margins and only, tech-oriented firms will survive. And I think what's overlooked in there sometimes is the good news story, that when it's used really well, technology can really help access to justice, and it can facilitate better and actually more rewarding legal practice. And so we tried to sort of talk about both sides of tech with the students to try and balance out that bad news story that they tend to get.
Yes.
But yeah, absolutely.
Yeah,
it's very
great. And so you talk about the difficulty of getting students to engage with end users.
Yes.
And then how you emphasize that in the second iteration. And again, that strikes me as really important, because even if we weren't engaged in innovation, I mean, one of the difficult transitions I always think a young lawyer has to make is to stop thinking about law as some kind of performance art, self-obsessed with law and its kind of purity and showing how clever we all are, and sort of beginning to think, no, actually, what about the client and what the poor old client wants? So that's an important lesson in itself, it seems to me.
It absolutely is. And I think in the case of our students at Newcastle Law School, we do come with a little bit of a built-in advantage there because we have an embedded clinical program. So our students do get experience in the legal clinic from their first year. So I've noticed that our students here, as opposed to some other places I've taught, are just that little bit further ahead in the mentality that it is about the client and that the client is a human. But absolutely. And I think actually what you're saying, Michael, is that because there's quite an interesting tension between what we do as educators. We can't teach just skills and we can't teach just content, but we have such a limited amount of time. And we've always got this juggling act of how we balance out the teaching of skills and those sort of formative features of identity versus actually teaching the things that lawyers need to know.
Yeah.
So I think in a way it's a real privilege to have a course like this where we don't have a lot of technical content that we need to cover, in fact, almost none.
Yeah.
And it is very skills focused. And so that's been a really wonderful sort of experience.
But in fact, there is content there, isn't it? Because the students, to do those things, they've got to engage with the content much more deeply than if they're doing a traditional course. But I agree with you. I suppose what you're saying in a certain sense is there's only so much front loading you can do. You can't, students aren't ready to think about what they'll be doing in 3 or 4 years' time.
Absolutely. And we don't have to teach doctrine, for example. There's no legislation that we well, there's a little bit of legislation, but there's not that much that we need to cover in this course. So we have that luxury of spending more time sort of talking about that meta of how to be a lawyer and that sort of thing.
Yes. Now, Lisa, we've actually got to say, because one of our speakers didn't turn up, so we've actually got a few minutes, and you did say you had a video. So at 3:25, we'll be on to our next speaker. But if your video is less than 10 minutes.
Oh yeah, the video is only about 50 seconds, I think. And so what it was just the impressions that some of our students had given about the course and what it was like to actually do the course. So let me see if I can manage this. Okay.
How I found it, it's been very hands-on, and it's been how can we actually change the legal system in how we do things. And I found that an interesting sort of unexpected result for me.
It's really such a refreshing course that we are our creative brain in how to actually maybe try and change things and fix things so that the end users, which is like the community, are able to access the legal system in a much better way.
I don't think that's ever been discussed in any law course in the history of the world. And I found from that moment on, the thinking that we engaged in was a lot different to our normal legal thinking. And even now going out into the real world and seeing real life situations, this course has really exposed us to what is needed in the real world.
All right, that's the end of that clip.
Very nice.
It's been very hands-on.
I'm sorry, there we go.
So that's terrific. So,
yeah, it was really nice to hear what they had to say. And that was actually something interesting that we did with the course, just because we do love our tech, even if we don't believe in teaching it all the time. But we had engaged very heavily through Twitter with people in industry, and we'd collected a lot of sort of photos and clips and pictures of what was going on, and we'd sort of sent that out into the world. And we'd had these experts sort of zooming in, so the students were able to connect through social media with some of the experts. So we had a fair bit of this sort of material by the end of the course.
So it's a lovely video, and what it made me think actually, or maybe want to ask one other question. Will you? Oh, sorry. Comment for Lisa. Great, from Marie Hadley. Comment for Lisa. Great clip. Fantastic to see the student experience. So that's just a comment from Marie Hadley. And so one little thing following up on that is, are you going to draw on students who've done the course to act as some kind of mentors or tutors?
Oh, that's actually a fantastic idea. We haven't done that so far, but that would be a really good thing to do. Yeah, I like that idea.
Good. Well, thanks, Lisa. I think we've run through the questions. So we thank Lisa for that fantastic presentation. We'll come back at 3:25, so in 10 minutes, for the next talk by Professor Anatoliy Kostruba.
Have a nice day. I'm very happy to take part in your scientific conference this morning. Let me say that I'm very grateful for your support in this station. And so let me share by the screen my conference. Here it is. Okay. The main vector of the development of higher legal education in Ukraine is determined by the general orientation of the national higher education towards entry into the pan-European and global education sphere, harmonization of national and international studies of higher education in the context of Bologna process. On the other hand, rapid development of information technologies has led to the global computerization of society. So consequently, the process of knowledge accumulation for the development of professional competence skills gradually changes, and form of implementation. Well-known goals of higher educationals that are discovered in such element as knowledge understanding forms and their gainings are subject to change. Unfortunately, such changes do not always have a positive educational trajectory. It must be admitted that educational institutions are no longer the primary educational resources. Those basic goals that a purpose of higher education do not receive appropriate positive response from society. High knowledge level without skills of their application is a major factor of the professional deformation of a graduate of the higher education institutions. This problem is clearly visible in the field of higher education. Public statistics sources indicate that persons with higher legal educations take one of leading place at about 26% among the total number of unemployed persons with higher education who have not been able to find their jobs. The analysis of theoretical and methodological resources and practice of work with students of higher education institutions show that the process of learning professional skills often stopped at level of unconscious incompetence or at best conscious incompetence. Therefore, the agenda is focused on the necessity for improvement of pedagogical model of the process of formation of the legal competence of the lawyer, and in particular, the component of its substantive and didactical segments. The use value of the purpose approach to the process of formation professional competence of lawyer is that under the condition of improvement of about segments. It's possible, firstly, to avoid overloading the curriculum with unnecessary courses, and secondly, to provide high-quality professional necessary differentiated training of law students during the entire period of study. Thus, the implementation of such a private methodological system achieve the integrity of the whole system of professional training of lawyers, which in turn will ensure the integrity and consistency of legal knowledge and linguistic skills, their practical implementation, and will contribute to formation of a level of conscious competence of law students. The concept of competence is defined in law of Ukraine and Half Education as a dynamic combination of knowledge, abilities, and practical skills, ways of thinking, professional, ideological, and civil qualities, moral and ethical values, which determine the ability of a person to successfully pursue professional and further educational activities, and is a result of study at a certain level of higher education. Defining the purpose of professional training of lawyer is a part of appropriate pedagogical model that can be defined as a target segment of the pedagogical model of the process of formation of the lawyers. Activity approach as a set of particular education technologies, techniques in the core of professional training of lawyers. It's a methodological basis on which the different training system with their specific technology, techniques, and theoretical features are built. In this way, we shift away from the method of knowledge translation and their basic gaining enable the achievement of educational goals that meet the need of society and the state. Within the target segment, achievement of a goal formation of future lawyers, readiness of professional interaction based on the basic principles of scientific approach and principles of organization of educational process. The second segment of the pedagogical model is a resource provision of professional training the lawyers. This model provides for the formation and implementation of the cycle of disciplines that provide the achievement of educational goals set with the first segment of pedagogical models. This segment solidifies a meaningful context of the pedagogical process for formation on the future lawyers and pedagogical materials concerning the professional competence of the lawyer. In our opinion, such cycle system substantially indicates human thematic legal disciplines and special purpose disciplines aimed at the extension of professional training. At the same time, the proportion of the distribution of time of the educational process should invariably increase toward the special purpose disciplines against humanity cycle, which corresponds to the competence-oriented approach of the modern higher education. Today, it must be admitted that large part of discipline that Ukrainian law students learned have nothing to do with law and future practice of law. It's important to provide basic and elective courses, which will save time for concentrating attention on mastering the thematic legal disciplines and special purpose disciplines aimed at the extension of professional training. By providing a meaningful component in development of competence of the future lawyer, this model formed accordingly a meaningful segment of pedagogical model of the process of formation of the lawyers. The third element of the pedagogical model of the process of formation of future lawyers is didactic segment. This block includes the stage of organizations of the educational process, blocks of theoretical and practical training of future specialists, teaching methods. These segments is comprised of the form of organizational of the educational process as a way of organizing, constructing, and holding classes in which the context of educational works, didactic tests, and teaching methods are implemented. Depending on the purpose, form of organization of educational process, are divided into lectures, practical classes, seminars, laboratory sessions, laboratory practical works, students' individual works, scientific expedition, excursion, educational conference, consultation, and etc. Currently, in motivated process or in the field of higher legal education result in the introduction of such new forms of educations as a legal clinic. Its purpose is to prepare law graduates of their future practical activities. Back in the 19th century, law faculty in different countries, Germany, Russia, faced to the problem of the gap between the level of knowledge, skills, and qualities of graduates and the requirement of employers for young lawyers' qualifications. Students studied serious scientific disciplines, and the experience was expected to be purchased later after graduation. In the countries of Anglo-Saxon tradition, the training of lawyers was conducted exclusively in the form of individual mentoring. The young man became the assistant of an experienced lawyer, and first he carried out small tasks, watched the work of the masters, and step by step was allowed to a more responsible independent activity. Current system of legal education in Ukraine is based on the formation of students' theoretical knowledge, which of course provide a certain level of quality students, future specialist trainings. In traditional academic studies, most of curriculum includes lectures and seminars. In the study of disciplines, emphasizing the place primarily on the subject content and specifically on the studied discipline. However, this approach doesn't fully allow students to have an understanding of cross-curricular links with special as well. An additional traditional teaching is based on explanatory, illustrative, and reproductive methods. This essence is reduced to the procession of transferring reading, known as a final knowledge of the students. The result is the students' passive attitude to learning. Legal clinic training in base of new technologies. It study works in the clinics. The students should not only keep in mind the information he traditionally received in classroom at academic session, but also to apply in the related sound practice, legal practices for appropriate interactive teaching methods, role-playing games, case analysis, small group work. To generate the system of professional training of lawyer, it's necessary to determine the scope of the professional training of law students. It's known that in complex and multi-phased professional activities of lawyers, the basic operations are following: fact-finding, legal evaluation of factual data, establishing legal behavior, that is correlation of the life situation with a specific legal norms, the goal of ensure its effectiveness. Procedural activities solve the case, and preparation of and execution of legal documents. All those areas of legal activity have determined a plate orientation in the future lawyers' professional training system. Finally, the evaluation of productive segments of the pedagogical model is of the process of preparation of lawyer constitutes in the last segments. It includes level preparedness of future lawyers for professional interaction defined on the basis of criteria, indicators developed, and methodological complex of pedagogical influence, which is aimed at correction of the obtained result in the process of preparation. The evaluation of performance component of the purpose model is designed to meet current labor market requirements for the training of law professionals. Control during the formation of the legal competence of the lawyer should meet the goals and objectives of legal education, have the adequacy and adaptability of control methods, objectivity of the relevant results. An important steps in the training for future lawyers is not only formation of professional skills, but also assessment of the level of their development. These shall be achieved through such technologies as test, control, and case studies. The principal innovation of this area is the unified professional entrance examination as a form of entrance test in law and general educated legal competence for admission for study for the master's degree of the basic of higher educational degree, which involves the use of organizational and technological process of external independent relation of entrance for entrance, and such a form of assessments of the level of specific special competence of students defined by the standards of higher educations and sufficient for effective performance of professional activity by occupation at the only state qualification examination. That's all. Thank you for your attention.